Well, good morning. Hello. Welcome to another of my daily updates about the current California Board of Psychology hearing coming up December 29th through 31st. It's open to the public, from what I understand, and this has broader implications. The ruling of this on this matter will will have both implications across all 50 states relative to the standards of practice, as well as up into Canada and internationally, Australia, England, Malaysia, Mexico, everywhere there's family conflict. This case is going to have implications. It's been brought by Doctors Burnett and Lorandos because I'm critical of them for their fabricated pathology and their continued advocacy for a fabricated pathology rather than the application of the DSM-5 and established knowledge. And they believe that's unethical to criticize them. But I'm saying that it is required by the APA ethical standards, and I don't really have a choice about that. So this isn't about patient care. This isn't about the public, other than the fact that this fabricated pathology is creating substantial harm for the court's decision making and for the parents and children in the family courts. We need to go back to established knowledge DSM-5, but this is a professional to professional dispute brought into the licensing boards. And I've known Dr. Burnett since 2011. So we have over 15 years of background together, about 15 years of background together. I've met with him twice personally. And this is purely a discussion of models. They propose they're discovering a new form of pathology, and I say it's already in the DSM-5, and if we use the DSM-5, everything would be solved. So today I'm going to be discussing particularly the APA Ethics Code and what's involved with this. And I would point out, to begin with, that the APA Ethics Code is mandatory. It's not optional. And so I asked Gemini, the AI, about mandatory, the word mandatory, and this is what it said. Mandatory means something is required by law, rule, or authority. It's compulsory, obligatory, and not optional. Key aspects of mandatory are compulsory. You have no choice. It is a requirement. So the APA, I have ethics guideline. I have no choice. Obligatory. You are bound by duty or rule to do it. Authoritative. It comes from a command or order. So that's your APA ethics code from the American Psychological Association. And it's binding. It cannot be ignored or modified, especially in legal contexts, such as a mandatory sentence. So the APA Ethics Code is mandatory. It's not optional. You have no choice. It cannot be ignored. Now, in the family courts, they treat it as discretionary and optional. The forensic psychologists and the self-proclaimed experts in parental alienation, because they're allowed to. There is no oversight. And who's supposed to enforce the APA Ethics Code? The state licensing boards. For, if you're violating ethical standards in California, that's mandated into law that we must, not a choice. It's not optional. We must follow the APA Ethics Code and comply with it. So let's talk about the various standards involved. Standard 2.01 is boundaries of competence. Here's what it says. Psychologists provide services, teach, and conduct research with population and in areas only within the boundaries of their competence based on their education, training, and experience, supervised experience, notice it says supervised, consultation, study, or professional experience. And then part C of that is that psychologists planning to provide services, teach, or conduct research involving populations, areas, techniques, or technologies new to them, undertake relevant education, training, supervised experience, consultation, or study. So that right there, that is not optional. And it's throughout healthcare. I mean, if you're a cosmetic surgeon, you just can't suddenly decide to do open heart surgery and have all your patients die. You may be a doctor, you may be a surgeon, but you're a cosmetic surgeon, not an open heart surgeon. And certainly a podiatrist shouldn't be doing open heart surgery either. And so in psychology, there's domains of competence. If you don't know about PTSD in war veterans, you're not allowed to go in and start diagnosing and treating PTSD in war veterans unless you get training or experience or consultation on it. So that's standard 2.01. And I want to point out that both 2.01A and C note consultation as one of the ways to acquire competence if we lack it. And that means that's a requirement, not optional. They have no choice, and it cannot be ignored. And that's the typical way by which, if we expand out into new areas, we will get consultation from somebody who is knowledgeable in that. Then we have standard 2.04, bases for professional judgments. Now, all the 2 series are competence standards. So 2.04, which is not optional, you have no choice, it cannot be ignored, is at bases for scientific and professional judgments. Psychologists' work is based upon established scientific and professional knowledge of the discipline. So this one is a critical one. This is the one that all the forensic custody evaluators are in violation. They're also in violation 2.01, but this is the most clear one because they are not applying the established knowledge because they don't know the established knowledge, but they don't apply it as a basis for their professional judgments. And that's true for the self-proclaimed experts in parental alienation, that they are required, not optional, not it's required, it's mandatory. They are required to apply the established knowledge first, before making up new forms of pathology. First, apply the DSM-5, apply attachment, and then if you want to propose new forms of pathology, you can, but you don't substitute your fabricated pathology with actual knowledge. No, apply the actual knowledge and then you can add to it if you want and propose new theories, but you don't do it instead of the established knowledge. So the established knowledge that is required, not optional, you have no choice, it cannot be ignored, relative to the pathology in the family courts, is the DSM-5 and persecutory delusions. That's what we're worried about on the path B, on the narcissistic borderline parent is collapsing into a persecutory delusion. So you apply the DSM-5, that's 297.1, about persecutory delusions, plus 300.19, factitious disorder imposed on another. So both of those major psychiatric disorders are relevant in the family courts. Apply the DSM-5. Attachment, but specifically disorganized attachment. Now, a child rejecting a parent is an attachment pathology. It's a problem in love and bonding. Let me say something about that. ADHD is a regulatory disorder. So there's a set point and then it's up and down around the set point. That's a regulatory disorder. Attachment is a motivational system. Eating, pain, pleasure, sex, attachment all motivate towards a direction. And the reason they motivate towards the direction of bonding to a parent is because the other motivational direction is death by starvation and predation. That's John Bowlby and attachment theory. That's the origins of a motivational system to bond to the parent. It always motivates that direction. So if you see a change in the motivational direction, that the child has no organized strategy to bond to the parent. That's a disorganized attachment. And the only thing that causes a disorganized attachment is child abuse or psychotic range parenting, because every other type of bad parenting results in what's called an insecure attachment that continues to maintain the motivation to bond to the parent. The only thing that creates a child wanting death by starvation or predation is if there's child abuse or psychotic range parenting. So if we see a disorganized attachment, we're pretty sure one parent or the other is either abusing the child or is in the psychotic range. Shared delusions, personality disorder, and persecutory delusions, because what we're dealing with is a narcissistic borderline personality. And those both are known to collapse into persecutory delusions under stress. The term borderline comes from the 1930s, and it's meant to signify the person or personality style is on the borderline of neurotic and psychotic. So right in the label for that, there's an acknowledgement that they collapse into persecutory delusions. And the narcissist, that we've got Theodore Milan, grand high expert in personality disorders, talks explicitly about the narcissistic personality collapsing into persecutory delusions under stress. So we know that. And then we have family systems, cross-generational coalition, triangulation, emotional cutoff. And we're treating a family. We're talking about families. So you need to be competent in families and family dynamics. Now, standard 9.01, bases for assessment. What this one says, not optional, it must be applied, you must be compliant with it, cannot be ignored, is that psychologists base the opinions contained in their recommendations, such as the recommendations for new forms of pathology, reports, diagnostic or evaluative statements, such as coming up with new forms of pathology, including forensic testimony, on information and techniques sufficient to substantiate their findings. And notice it refers specifically to standard 2.04, that's the DSM-5, attachment, delusional thought disorders, personality disorders, and family systems. And so it is required to apply that knowledge first, and to base your recommendations to the public, to base your diagnostic and evaluative statements, and including your forensic testimony on the information and techniques to substantiate your findings, the established scientific and professional knowledge of the discipline. Excuse me. And so that's the knowledge that should be applied. That's the knowledge that is not being applied. And the reason it's not being applied is because they don't know it. The violation of 2.01, they don't know the knowledge, so they don't apply the knowledge. So I've got two ethical violations, and because of that, their recommendations and reports and forensic testimony are not based on information and techniques sufficient to substantiate their findings. 3 violations. And so now that cascades into our 4th violation, which is to standard 3.04, avoiding harm. And this is the one that is most egregious and most just substantial, captivating, is avoiding harm. This is not optional. You have no choice, cannot be ignored. Psychologists take reasonable steps to avoid harming their clients, patients, students, supervisees, research participants, organizational clients, and others with whom they work, and to minimize harm where it is foreseeable and unavoidable. So, the reasonable steps. It is reasonable for a doctor to apply the DSM-5 as the basis for their professional judgment, standard 2.04, to avoid the harm of misdiagnosis if the DSM-5 is not applied as a basis for their professional judgments. So simply to skip applying the established knowledge 2.04, violate that as if it's discretionary, as if it's optional and you don't have to do it, will lead to the violation of 9.01 and the violation of 3.04. So that's your cascade. 2.01, they don't know the knowledge. 2.04, they don't apply it. 9.01, they're not basing their judgments on sufficient information, causing harm from misdiagnosis. 4 ethical violations, and that's true of all the forensic custody evaluators. That's true of all the PAS experts or self-proclaimed experts in this new form of pathology. Violation of 2.01, they don't know it. 2.04, they don't apply it. 9.01, the recommendations are not based on sufficient information, and 3.04, it causes harm from misdiagnosis. Those are the violations. Now let's talk about me. Standard 1.04, informal resolution of ethical violations. Here's what it says. When psychologists believe there may have been an ethical violation, I don't need to prove it, I just need to may have been, and I believe there may have been, I believe there is violations to 4 ethical standards by another psychologist, by group of forensics by psychologists, though all the psychologists working in the family courts where they can just make things up. The psychologist attempts to resolve the issue by bringing it to the attention of that individual. Okay, so we don't rush right to the licensing boards. We bring it to the attention of the individual and seek correction of it or seek correction of their behavior or activity. Instead of running to the licensing boards and saying, oh, you're violating ethical standards. Informal resolution of the issue. And that's required. It's not optional. I have no choice. It cannot be ignored. So I've met directly with Dr. Burnett regarding my concerns, met once in Boston around the AFCC convention, and then we were both presenting over in Venice, Italy, and I hosted a dinner for my wife and myself and him and his wife, and Dorsey Pruder was over there doing business, and there was a parent advocate, and so I hosted a dinner for all 6 of them where Dr. Burnett and I discussed the concerns regarding his continued use and promotion of fabricated pathologies. We also met around Boston too. That was also witnessed by Dorsey Pruder. That's one of her exhibits is the letter, and I intend to call her as a witness to discuss what happened at those meetings. Pursuant to standard 1.05, I have it documented. I met informal resolution. Standard 1.05. This is mandatory for me. This has to do with reporting ethical violations. It's not optional. If an apparent ethical violation, it doesn't need to be proven. If an apparent ethical violation has substantially harmed or is likely to substantially harm a person or organization, and it is not appropriate for informal resolution under 1.04, or it is not resolved properly in that fashion, psychologists take further action appropriate to the situation. And that's where the entire Board of Psychology case hinges, is on that statement. Psychologists take further action appropriate to the situation. Then it offers some recommendations. Such action might include referral to a state or national committee on professional ethics, that's the APA ethics committee, to state and licensing boards, and so those are obviously all the 50 state licensing boards, or to appropriate institutional authorities. Typically that's in universities, but in this case, it's the AFCC. So let's take a look at, I want you to notice that key phrase, psychologists take further action appropriate to the situation. That's got 2 components to it. And if anybody's familiar with the legal system, legal statutes, it's got 2 clauses that both must be fulfilled. that it says psychologists take further action. It doesn't say psychologists consider further action or psychologists may take further action. It doesn't give any leeway on that. We are required, mandatory, not optional. We do not have a choice. It cannot be ignored. We must take further action. And the second part is that action must be appropriate to the situation. And that's critical. What's appropriate to the situation of institutional capture and regulatory capture? That's Stigler, where the forensic psychologists are performing this experiment on human subjects without IRB approval, without risk-benefit analysis, without protections for a vulnerable population, and are completely disregarding the APA ethics code, are not applying the DSM-5, are not applying attachment. They're in violation of all 4 ethical standards, and it's within that culture that these pseudoscientific things, these made-up pathology labels can flourish because nobody's enforcing ethical standards. And so that goes to the whole history of my 15 years in the family courts, where I have notified the AFCC at their national convention. I have slides, and that's one of the exhibits. And I have notified the American Psychological Association, APA Ethics Committee, hand delivering a petition signed by 19,000 parents describing the ethical violations. No response from the APA, none, zero. That's just contempt for the parents who are seeking their, and I'm doing everything I'm required to do, but there's no one receiving my duty to report ethical violations. And because it's abuse pathology, child abuse and spousal, I have a clinical duty to protect. I have an identified victim in imminent danger of abuse. And there's no place to discharge my duty to protect. And so those are the standards that govern my action in the situation. Now, the board is alleging I violated standards on being critical of other professionals. My argument is that I'm required to. I don't have a choice. It's not optional. I must take further action appropriate to the situation to mitigate against the substantial harm that's being created. So the situation, I'm appropriate to the situation, is regulatory capture. That's Stigler. The APA Ethics Committee is inert. There's no action. That's the 19,000 petition to the APA. The AFCC is inert. There's no action. That's direct notification at their convention. Plus, for both of those, I've been documenting this into the record on blog posts and essays and books and everything for 15 years. And in the response of the AFCC instructors to my letter, informal 1.04 letter, if you read that, their response, they say they're familiar with my work. Well, if you're familiar with my work, then you know the ethical violations involved, 2.01, 2.04, and you are required to consult, okay, or get competent yourself. I have not talked to a single forensic psychologist on consultation. I have not talked to a single self-proclaimed expert. They're not consulting with anybody. It is absolutely a free-for-all in the family courts. You can ignore the APA ethics code. You can entirely disregard it. And there's no accountability. Who's responsible for enforcing the APA ethics code? The licensing boards. So it's obviously they're not doing it because it's just everybody can make up whatever they want. And the APA ethics code is optional for the psychologists working in the family courts. So here's from Freud, having to do with institutional betrayal trauma. Institutional betrayal occurs when institutions people depend on for safety and well-being fail to protect them or engage in actions that harm them. Notice where that comes from, the Journal of Traumatic Stress. Freud, again, institutional betrayal includes acts of omission and commission by an institution that betray the trust of those dependent upon the institution. And then we have Stigler about regulatory capture. Regulation is not directed at the protection of the public, but at the protection of the regulated industry. So that's the appropriate to the situation context in which I must take further action, must take. Now, as for me, I have documented expertise, not only competence, expertise, high level expertise in attachment. I have early childhood mental health specialization from out of Dr. Polson's training at CHLA. Then I know 2 additional diagnostic systems. I know 2 attachment treatments, and I'm certified in infant mental health. That's the attachment system. I know what I'm talking about. Delusional thought disorders. I have 12 years of annual diagnostic training in the assessment of delusional thought disorders to a 90% reliability with gold standard experts in using the BPRS, Brief Psychiatric Rating Scale. The authors of the BPRS, Dr. Ventura, Dr. Lukoff, I am trained to 90% diagnostic reliability for 12 years. We watch videotapes every year and we'd have to rate them and they would have their gold standard ratings. I'm one of the best trained people on the planet in identifying delusional thought disorders. Does anybody consult with me? No. Child abuse and complex trauma. I was the clinical director of a 3-university assessment and treatment center for children referred by the Child Protective Services. Okay, I'm not just working at the clinic, I am the clinical director for the child abuse clinic with attachment expertise, with delusional thought disorder expertise, and not a single forensic custody evaluator has ever consulted with me. Not a single PAS, self-proclaimed expert, has ever consulted with me. In fact, they ignore my consultation. I'm telling them, you need to get competent, and they just ignore it. Okay, in violation of 9.01C, or 2.01C, about if you're not competent, you must, required, not optional, consult. They just ignore it and continue to promote made-up pathology labels that mask and hide the child abuse, because everybody gets arguing about whether it's parental alienation instead of whether it's a delusional disorder, whether it's a factitious disorder, major psychiatric disorders. Does the court know that this could be a major psychiatric disorder? No. Why not? Because it's being hidden from them by these parent-child contact problems, is what the custody evaluators are bringing in. Their new made-up pathology label, resist-refuse dynamic. We'll see how they're bringing that in a second. Everybody's allowed to make up whatever they want. New forms of assessment, child custody evaluations, new forms of pathology, parental alienation, parent-child contact problems. Nobody's required to apply the established knowledge. It's an absolute nightmare. So here, Walters and Friedlander in the journal Family Court Review. Now, Family Court Review is the flagship journal of the AFCC, Association of Family Conciliation Courts. It's the professional organization that is a platform for promoting forensic custody evaluations in the courts. In some RRD families, that's resist-refuse dynamic. So that's an example right there where they're making up a new form of pathology, this new label. In some RRD families, there's no such thing as an RRD family. A parent's underlying encapsulated delusion about the other parent is at the root of the intractability. And they cite Johnson and Campbell, but look at that, they cite me as the expert. An encapsulated delusion is a fixed, circumscribed belief that persists over time and is not altered by evidence of the inaccuracy of the belief. And when I read that, it cracked me up. Because if you work delusions, if you work psychosis, it's a fixed and false belief maintained despite contrary evidence. That's the statement. But my guess is they thought they didn't want to plagiarize me or something, so they use other words. They use their thesaurus to explain it. A fixed and false belief maintained despite contrary evidence. That's a delusion. The type of delusion is a persecutory delusion. That's a fixed and false belief maintained despite contrary evidence that the person or someone to whom the person is close is being malevolently treated in some way. Google malevolent, having or showing a wish to do evil. So the child believes they are being malevolently treated in some way by the targeted parent, and that's false, and it's a fixed false belief. And the allied parent falsely believes that child is being malevolently treated in some way. That's a persecutory delusion. Okay, and that's the definition. And if they know it, they should be applying the established knowledge around delusions. They should be knowing the established knowledge. Now, the assessment for delusional disorder, you can go to my website, and I got all the YouTube videos. I got a whole video on the diagnostic series on how to assess for delusional thought disorders. It's a mental status exam of thought and perception. That should be conducted in every one of these cases. However, they don't know how to do that. They're practicing beyond the boundaries of their competence. Information, delusional thought disorders, techniques, mental status exam of thought and perception. Oh, well, they can just disregard that and disregard the APA ethics code because somehow they're special in the family courts. Going back to Walters and Friedlander, when alienation, see, they're bringing that same sort of fabricated pathology back. And look how they've done the resist, refuse, and alienation. They're just switching out their fabricated pathology labels here. When alienation is the predominant factor in resist, refuse dynamic, the theme of the favored parent's fixed delusion often is that the rejected parent is sexually, physically, or emotionally abusing the child. The child may come to share the parent's encapsulated delusion and to regard the beliefs as his or her own. Look to who they cite. Me. They know it's 2016. They know it's a delusional thought disorder. They know I'm expert in this. Not a single, not one forensics custody evaluator has ever consulted me regarding the diagnostic assessment of delusional disorders. In the family courts, the APA ethics code is just disregarded. And it's within that context, that's the situation that my response must be appropriate to. If they were consulting with me, that's easy peasy. I say, apply the DSM-5, here's how, everything's solved. But they don't. Why not? Because if they start applying the DSM-5 and diagnosing the pathology, we don't need their custody evaluations. We can conduct a clinical diagnostic assessment in 4 to 6 weeks for around $2,500. 4 to 6 weeks, $2,500. Their forensic custody evaluations take 6 to 9 months. So I've seen some last as long as 2 years for an assessment. 2 years to get an assessment for possible child abuse, and cost between $20,000 to $40,000, sometimes more. $2,500, $20,000 to $40,000. 4 to 6 weeks, 6 to 9 months. Requires knowledge, requires no knowledge. That's why. That's why they don't acknowledge anything I'm saying. That's why they don't consult. That's why they simply disregard everything I'm saying. Just like they disregard the APA ethics code. They disregard the violations that I'm talking about all the time, 2.01, 2.04, 9.01, 3.04. I've got blogs and blogs on that. They just simply disregard the ethical violations. 1.04, 1.05 has no effect on them. So When psychologists believe there may have been an ethical violation by another psychologist, I believe there's been violation 2.04, 2.01, 9.01, 3.04. Psychologists take further action appropriate to the situation. That's not optional. That is mandatory. That is required. And standards 1.04 and 1.05 are the self-corrective ethics standards. Notice there are two standards. The AP Ethics Code didn't put them into one standard as two parts. If, informally notify them as A and B, if not, go. It gave them two separate standards because it's that important. It's a self-corrective standard, and it's talking to what the psychologist must do when they recognize ethical violations. Okay, that's because the public may not always recognize the ethical violations. Psychologists should and do. And so when we do, even at the low standard of may have been, boom, we are required to act to correct the situation because that's how serious ethical violations are. They hurt people, and they can hurt people substantially. So the APA Ethics Code is mandatory, not optional. You have no choice. It cannot be ignored, except in the family courts, where it's absolutely entirely acceptable to disregard the APA Ethics Code because, I don't know, for some reason. Your state legislators oversee the licensing boards. Your state legislators work for you. The licensing boards are supposed to protect the citizens, not the unethical psychologists. So the reason in 2025, all you parents are in the family courts globally, but in the United States, Canada, England, well, the reason you're here fighting and going to the courts and spending tens of thousands, hundreds of $1,000s on attorneys' fees over years and watching your children be psychologically abused and nothing happens, the reason for that is because the parents who came before you didn't get a hold of their legislators and get appropriate mental health services for themselves. Abuse pathology. Now, remember, I'm high-level child abuse and complex trauma. Abuse pathology isolates its victims from reporting and rescue. You can think about the spousal abuse husband who isolates the wife from her friends and family, isolates her from reporting and rescue. You can think about the sexual predator who isolates that child from reporting and rescue. That's a classic feature of abuse pathology. That's exactly what's happened in the family courts. The parents and children have been isolated by forensic custody evaluations that are an experiment on human subjects. There's no quasi-judicial role for doctors. Doctors diagnose and treat. We don't advise the court on its custody decisions. That's a court's decision. Doctors diagnose and treat. That it's an experimental role. And then they came up with this experimental assessment procedure called a forensic custody evaluation. 6 to 9 months, doesn't diagnose. It's just fabricated from start to finish. And that's allowed. You've been isolated from reporting and rescue. Now, the whole thing with these self-proclaimed experts in parental alienation is that's a sideshow. It gets everybody talking and fighting about that and keeps everybody in controversy because we're focused on the wrong thing. We need to be focused on the DSM-5, on the actual stuff, but instead we're arguing about these fabricated pathologies for 40, 50 years. It solved nothing in 40 years. No solution. Let it go. Stop it. There's no such thing. In 2013, it was fully reviewed by the American Psychiatric Association. No, they rejected it entirely, not even by a mention. But they just won't take no for an answer. They just won't apply the DSM-5. They just say no. They're not going to, and that's a violation of 2.04. And it's like, oh my God, it's so bad. And so instead of taking corrective action, what do? They silence the whistleblower. So the system is trying to remove me from the family courts, remove the only competent psychologist who's here, the one who is taking steps, the ethical required steps to protect the vulnerable population, to protect the citizens of the state against unethical psychologists. They're seeking to remove me from the family courts so that you're left with the forensic custody evaluators and the self-proclaimed experts in parental alienation, as you have been for 40 years with no solution, and destroyed children's lives, destroyed parents' lives. That's what this matter is about. And so I'm put my license on the at risk because that's what ethical psychologists do. Okay, I have a duty, not optional. It's not my choice. It's mandatory. And there's reasons for that. And one of the reasons is that it will expose the institutional capture and correct the system. The treatment for institutional capture is called institutional courage. That's Freud as well. So with that, I'm going to head off to my day. We have oral arguments coming up on some motions in Lamine. I'm going to spend my day preparing for those oral arguments. Those might be subject to public as well. I don't know at this point, but if legislative analysts or legislative aides want to sit in and watch their licensing boards at work, that's fine. Now let me say, I have complete and full confidence in the judiciary. Okay, not a question about them. Okay, the question has to do with those who are facilitating the charges within the broader board as to their judgment in this situation. I do not have a question as to the courts or the administrative law judges' judgment. Not a doubt. Okay, so I am confident that we will get an adequate and reasonable resolution to the situation. But I have duty to protect. And if the California Board of Psychology does not accept the discharge of that duty, then I am required, I carry that duty, and those requirements continue. And not right now, because of the charges and everything going before me, I believe the legislative oversight is appropriate as to whether this was the intent of the state legislatures. And I would suggest, and this is my Exhibit 30, my settlement counteroffer, I would suggest the first number one thing you do is put a moratorium on forensic custody evaluations. New York Blue Ribbon Commission says they are dangerous, harmful to children, and result in potentially disastrous consequences for parents and children. That in itself should be enough to cause a review by the licensing board. Let's put this on a moratorium. They are in violation of Standard 8.01 regarding institutional review boards and experiments on human subjects. And so their custody evaluations are in violation of Standard 8.01 and of all three principles of the Belmont Report that has to do with experiments on human subjects. And they are withholding clinical diagnostic assessments and giving the courts only their forensic custody evaluations while they withhold diagnosis and withhold DSM-5 and all the established knowledge, and they just make stuff up. So with that, I'm going to head off to my day, and we'll check in with you tomorrow. So take care, everybody, and good luck.